In this video, I'll show you June 24th, 2023. Officer Sidoti of the Cleveland Clinic Police Department stopped local resident Keith Golston during a workout in the Cleveland Clinic parking lot in Cleveland. After receiving a report that an individual matching his description was looking in vehicles, Officer Sidoti grabbed Mr. Goldston's arm to physically detain him, and Mr. Goldston began to film the encounter. You're about to get a lawsuit.
You're about to get a lawsuit.
You fit the description.
You have no
Red t-shirt,
legal
white
right.
shorts.
You have no legal right
Call that you're looking at
to put your hands on me.
Sir.
This is an assault.
Sir.
What's your name and badge number?
Sir, can you please turn around?
What's your name and badge number?
Officer Sidoti, 190.
You're about to get
What's
a lawsuit.
Your name, sir?
You have no legal right to ask me my name.
Sir, we got to call
or to put
that
your
you're
hands
looking at
on
people's
me.
vehicles. All right, and you won't identify yourself, you wouldn't stop, and you're on
You have
private
no
property.
legal right to identify me.
We got a call that he was looking at people's vehicles, and he wouldn't stop.
This character saw me up on the hill exercising, going through the lot. He started his car. He was up there sleeping or reading or something. Follow me down and stop me over here. I exercise here every day.
Okay. I'm here.
He put his hands on me
I've never
with
seen
no legal reason.
We got a call that
I got it on film.
Okay.
What's your name, officer?
You have an ID on you?
Officer Buchanan.
Look, he has no reason to ID me. No legal reason. You all about to get a huge law.
Mr. Goldston argues that Officer Sidoti had no legal reason to detain and identify him, and that Officer Sidoti assaulted him by putting his hands on him. According to Ohio's Stop and Identify law, which is codified in Section 292(1.29) of the Ohio Revised Code, quote, "No person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by a law enforcement officer, who reasonably suspects the person is committing, has committed, or is about to commit a criminal offense." In the 2023 case of State v. Blair, the 2nd District Court of Appeals of Ohio concluded that for the purposes of this statute, quote, "A public place is somewhere ordinary citizens are regularly permitted to be." And in the 2017 case of State v. D.C., the same court determined that an individual was in a public place for the purposes of this statute when he was asked to identify himself in the parking lot of a closed business. We will discuss whether Officer Sidoti had reasonable suspicion to detain Mr. Golston later in this episode. But for now, it is important to note that a court would probably find that the parking lot qualified as a public place under Ohio's Stop and Identify statute, even though he was on privately owned property, and that Mr. Golston was therefore required to identify himself if Officer Sidoti had reasonable suspicion that he was involved in criminal activity. Additionally, regarding Mr. Golston's allegations that Officer Sidoti assaulted him by using physical force to detain him, assuming, for the sake of argument, that Officer Sidoti had the reasonable suspicion necessary to legally detain Mr. Golston, it is likely that a court would find that Officer Sidoti's limited use of force was reasonable. As the Supreme Court noted in the 1989 case of Graham v. Connor, quote, "Our Fourth Amendment jurisprudence has long recognized that the right to make an investigatory stop necessarily carries with it the right to use some degree of physical coercion or threat thereof to effect it. And in the infamous Terry case itself, the officer grabbed the suspect and physically spun him around before frisking him. Likewise, the Sixth Circuit Court of Appeals, which has jurisdiction over Ohio, stated in the 2001 case of U.S. v. Heath that, quote, "This circuit permits the use of force such as handcuffs and guns to effect a stop when such a show of force is reasonable under the circumstances of the stop." In this situation, Officer Sidoti used a less intrusive method of force than handcuffs and firearms, as he only grabbed Mr. Goldston's arm, and he stated that he only used force. After Mr. Golston refused to stop, accordingly, a court would likely determine that the force used was reasonable, as long as Officer Sidoti had reasonable suspicion to detain Mr. Golston.
Saw him assaulting. when you walked up. Am I right?
I don't see you doing anything.
Absolutely.
All right.
You did.
Sir, I just need your ID. So
You're
I can
about
ID
you
We got-
escalated this thing. You
Sir,
escalated it.
Just talk to me, just talk to me,
You.
just talk to me.
We're not going back. This is a lawsuit now.
Okay. All right.
This is a lawsuit.
Sir, we got a call that you're
And
looking
I'm
through
suing
people's
you
vehicles.
personally
We got a call
for
that
putting
you're
your
looking
hands
through
on me.
people's vehicles.
I'm dressed to exercise. I do this every day. You're
We got
going
a
to pay
call
me.
that we were looking through people's vehicles. So
That's
I'm
no
responding to the
reason.
call. I'm
That's
responding to
no
the call.
reason for you to put your hands on me.
You wouldn't
and
identify. You wouldn't stop and
you
talk to
gave
me.
me
wouldn't
no
identify yourself
legal
when you're on
reason.
private property.
Officer Sidoti explains that he stopped Mr. Golston based on a call that someone matching his description was looking through people's vehicles. And Mr. Golston argues that he should not have been stopped because Officer Sidoti did not personally observe him doing anything criminal. However, as the Supreme Court noted in the 2014 case of Navarrete versus California, it has now, quoting, firmly rejected the argument that reasonable cause for an investigative stop can only be based on the officer's personal observation rather than on information supplied by another person. Therefore, it is possible for an officer to obtain the reasonable suspicion necessary to detain an individual based entirely on information reported by a third party. Now, although merely looking into vehicles is not a crime, this behavior could indicate potential future criminal activity such as theft. And as the First District Court of Appeals of Ohio explained in the 2005 case of State v. Burnett, quote, "It is not necessary to justify a stop under Terry that any criminal activity have actually taken place." The defendants in Terry had not broken any law, but were doing nothing more than loitering on a corner in front of a bank. To effectuate a Terry stop, it is only necessary that the police have a reasonable, articulable suspicion that criminal activity is afoot. In the Burnett case, the court agreed with the lower court's determination that officers had reasonable suspicion to detain an individual after a citizen reported that he was repeatedly walking up and down a street that had a history of thefts from autos and looking into car windows. In reaching this conclusion, the court argued that, quote, "In a neighborhood with a high incidence of car brake insurance, a stranger walking down the street stopping to look through car windows is, by any objective measure, suspicious." However, in the 2007 case of Sri Sabbath v. City of Brentwood, the Sixth Circuit Court of Appeals held that an officer did not have reasonable suspicion to conduct a Terry stop when he responded to an anonymous report of teenagers wearing baggy pants looking into cars in a parking lot. In this decision, the court strongly emphasized the fact that the tip was anonymous and that it, now quoting, provided only a vague description of possible suspects, described no ongoing criminal activity, and offered no prediction of future activity that could be used to determine the tipster's veracity and reliability. As for the situation in this encounter, we do not have enough information to determine whether, under the totality of the circumstances, Officer Sidoti had reasonable suspicion to detain Mr. Golston based on the report that he was looking into car windows, as it is unclear whether there had been a history of theft, or if the tip was anonymous or offered information proving its reliability. And although the case law suggests that a report of an individual looking into car windows can provide reasonable suspicion in some instances, other precedent indicates that there are also situations where such a tip is insufficient to justify a Terry stop.
You should have thought this out before escalating it. Yeah, get Garfield here. I'm staying here now. This is a police report. Nah, bruh, we're not going backwards from here. I'm sorry. Nothing personal against you.
Okay.
He should have never put his hands on me.
All right.
I have a legal right to defend myself when you do it. Either that badge does not give you the right to put your hands on me.
I got a call that you're looking through
You
people's
questioned me
vehicles.
about it. What did I say?
I have a
What
right
did
to
I
identify
say?
you too. When I'm
You don't
speaking
have
with
you.
You're on private property.
You don't have name the legal right that I have to identify, and I've committed no
What's
crime.
your reason of being here?
And I've committed no crime. I've told
What's your
you
reason of being
several
here?
times.
Exercising.
I'm here
correct?
every day.
You have no Cleveland Clinic business.
Let's see
And
if
you're on
this stands
private
up in court. You can't grab people up on a say-so. You didn't see me. You observed me for at least
We got-
45 seconds to a minute, and I confirmed what you saw, irrespective of what someone said. Irrespective of you getting a call, you have to articulate what crime I've committed that I have to ID. I know my rights.
How you doing, sir?
How you doing? You Garfield?
Police. Yeah, I'm Garfield.
My name is Keith Golston.
Nice to meet you, sir.
I want to file a police report. I got this guy on film assaulting me without probable cause, grabbing me, trying to twist my arm behind my back, putting his hands on me.
You know what yes, you have a right to do what you need to do, but this is a clinic, which means it's private. So if they ask you to do something, you gotta listen to them.
No. Let's test that legally.
Well, see, sir, this is a private.
I don't want to, bruh. It don't.
You can't even. You're not even supposed to be filming here.
Bruh, you don't know what you're talking about because
Don't tell me
he's
I don't know
claiming
what I'm
you
talking
don't.
about.
You don't know what you're talking about. He just claimed that this was private property.
It is private property. Which
Yeah.
means you have to do what they ask you to do.
No,
Yes,
I
you
do
do.
not.
You can't use this as a gym.
Hey, look.
I understand what you're saying. I do.
No, I can do anything I want to do, man.
This is a private
Yes, I
property.
can.
You're not supposed to be filming here.
Stop me then.
Well, see, that's where you go wrong. You can't. If I went to your house and you asked me not to do
This
something,
is not my house.
Whatever.
We're outside on.
The security guard contends that filming in the parking lot is prohibited due to its private property status, whereas Mr. Golston asserts that he has the right to film because he is in a public space. As we've discussed many times on ATA, several federal appellate courts have acknowledged that the First Amendment protects certain aspects of the right to film in public, including the right to record law enforcement officers while they are performing their official duties. For instance, in the 2000 case of Smith versus City of Cumming, the 11th Circuit Court of Appeals held that, quote, the First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. However, as we have discussed before here on ATA, the First Amendment only prohibits government actors from limiting speech and doesn't prevent private parties from restricting speech or forbidding certain types of speech, such as filming on private property. As the Supreme Court explained in the 2019 case of Manhattan Community Access Corp., versus D's, like the Constitution, does not disable private property owners and private lessees from exercising editorial discretion over speech and speakers on their property. Likewise, in the 1972 case of Lloyd Corporation versus Tanner, the Supreme Court concluded that a shopping center could legally expel protesters, even though the center was open to the public and used for certain meetings and various promotional activities, stating that there is no open-ended invitation to the public to use the center for any and all purposes, however incompatible with the interest of both the stores and the shoppers whom they serve. Here, the Cleveland Clinic is not a public government-owned hospital, and the private owner retains the right to regulate speech on its property. As such, it is almost certain that a court would determine that the Cleveland Clinic had the authority to prohibit filming on its premises, even though it is generally held open for public access.
if it's your property, then you got a right.
Whatever his name is, I'm filing a lawsuit for assault and battery.
So these guys, they have a right to talk to you.
He doesn't have a right to put his hands on me, bro. We were all right when we were talking.
I don't know what lead to that, but
I'll tell you
what
what.
lead to that? Why he?
I'll tell you what.
You know, if this guy,
Bruh.
if this officer asks you to leave and you don't leave, that's a crime because they're going to be criminal trespass.
He didn't ask me to leave.
It's a private
He didn't ask me to leave.
place,
You're making
okay?
stuff up now.
I'm not. That's why
Bruh,
I asked you.
Do you have a supervisor here?
Yeah, we do have.
Okay, let me file a report with your supervisor. Now, I want to file a criminal complaint. You guys are the reporting officers.
No,
I
we're
want
not.
to file.
This is Cleveland Clinic. If
they're-
you want,
Did he call you?
yeah, they called us.
They're
Y'all don't have no jurisdiction.
That's that. They are police department.
You want to file?
Where's the supervisor for
My-
Cleveland Clinic Police
Right now
Department?
it's me, but my supervisor's at home. Tanika
Who
Nett.
is here today besides you that I can make a report about this incident?
My partner, but
Let's get him here.
he's not a supervisor. He's right here, right behind me.
What's your name, sir? We can talk now.
All right, what's going on, bro?
You heard what was going on.
I heard what's going on.
Right.
All right. So do you want Marcus's number?
Now I want to get something legally on paper. right now.
Do you want to write it down on a statement, or you may just write this down now? I'm gonna get your statements like that. Want me to go do that?
Yeah, let's do that.
Okay. You come with me.
Now I have business on the property, right? No, I'm talking to him.
I don't know what's going on, man. So, he just grabbed you and stuff like that?
Absolutely.
That's crazy.
I stopped and I talked to him and I
Uh-huh.
let him know exactly what I was doing.
Yeah. I just wish,
We're gonna take it through the proper channels.
all right. Yeah, I'll give you my name. It's like that. You want to go somewhere else, or you just
Yeah, I want to go sit down.
Yeah, let's go. Should never got that honestly.
Mr. Golston followed Officer Buchanan into the hospital facility to file a report on the encounter, but it is unclear whether he spoke to anyone else regarding the incident or escalated his complaint. Additionally, although Mr. Golston stated several times during the encounter that Officer Sidoti's actions warranted a lawsuit and he would be filing one, we could not confirm whether he has pursued legal action or whether any disciplinary action has been taken against Officer Sidoti. Overall, Officer Sidoti gets a B-, because although it is possible that a court would find he had the reasonable suspicion necessary to detain Mr. Golston, he overlooked opportunities to utilize less invasive methods of investigation into Mr. Golston's conduct, and he failed to de-escalate the situation once Mr. Golston made it clear that he was simply exercising. Regardless of whether or not Officer Sidoti had reasonable suspicion to detain and identify Mr. Golston, a less intrusive and arguably more effective investigatory approach would have been to simply observed Mr. Golston's behavior in the parking lot to determine if he was engaging in any criminal activity. Now, while it likely would have been evident that Mr. Golston was simply exercising if Officer Sidoti had taken the time to watch him, it is unclear exactly how knowing Mr. Golston's name would have done anything to confirm or dispel any suspicion that Officer Sidoti might have had regarding Mr. Golston's activities in the parking lot. The over-reliance on Terry stop identifications is a common mistake we see officers make on this channel, and this episode serves as an important reminder that detaining and identifying suspects is only one of the many tools that officers can use when investigating potentially suspicious activity. Mr. Golston gets AB because although he demonstrated some misunderstandings regarding Terry stops, Ohio's identification laws and the First Amendment, he respectfully but forcefully voiced his objections and strongly advocated for his constitutional rights. That being said, his refusal to identify himself potentially violated Ohio's stop and identify law, as it is possible that a court could determine that Officer Sidoti did have reasonable suspicion to detain him. Now, while I sympathize with Mr. Golston's frustration at being stopped for simply exercising in a parking lot, it is essential that citizens understand that there are situations where officers are authorized to detain or even arrest individuals who have not committed any crimes, just as I do not have sufficient information to predict whether a court would conclude that Officer Sidoti, though he had reasonable suspicion to detain Mr. Golston, a citizen typically does not know everything that an officer stopping them knows. And this encounter demonstrates why it is often in a citizen's best interest to comply with officer identification demands in situations like this, particularly in states. Thank you very much for watching the video. Subscribe our channel for next video.